Okay, so like I said, my name is Gerald Polanco, and I'm an attorney with Uptown People's Law Center. We are located on Sheridan, just north of Montrose, where Jake's is. Of course, because of COVID, we aren't taking any walk-ins right now. But before people could just walk in and we would talk to you, maybe do an intake or schedule for a time. But feel free if you do need some legal advice or just want to talk to us, call our number. We're available online. You can also contact Sean and he can send a referral to me and then we can screen you that way. We do 3 general areas of law: tenants' rights, disability benefits, and prisoners' rights. So tenants' rights is sort of what we're going to talk about today. Disability rights, disability benefits, we're talking here about Social Security appeals or reconsideration. So if you've applied for Social Security, whether that's SSI, SSDI, other forms of Social Security, and you were denied, we can assist you with the reconsideration and appeal at the administrative law judge level. That is sort of the judicial level. And then prisoners' rights, which none of you really would be involved in or would have really referral for us unless you have a loved one in Illinois Department of Corrections. But it's essentially the branch of our office that does work in terms of civil rights cases in the Department of Corrections for the state of Illinois. So if someone is being mistreated, conditions while they're in prison, access to healthcare, things like that. So eviction, right? So that's sort of the heart of tenants' rights, right? Is, how to prevent an eviction, what happens with the eviction process, how to get out of an eviction. And so we're going to talk a little bit general about what the eviction process is and a couple little special protections along the way. And we're going to talk a little bit about COVID and how that's affected the eviction court process as it is. So this is sort of the typical eviction process. So you get an eviction notice, you get the landlord then files. There's a court summons where you get something from the sheriff's office or a special process server. We can talk a little bit more about that later, telling you have court. Your first day in court, there's a couple of ways that could go. The court hearing, so that might be that first day, or it might be the second day in court, or several days in court. But a hearing is essentially any time you go in front of the judge on issues of the case at hand, right? And the eviction order, that is to say, when the judge issues the order of possession, giving the landlord the power of possessing the unit. But it doesn't really end there, right? There's a little bit more time left for you. And so we're going to talk a little bit about that later. So sort of like before, right, we talked about eviction notices. These are the 3 kinds of general eviction notices: 5-day notices, which are generally for unpaid rent or illegal activity; 10-day notices, which is for a lease violation; and a 30-day notice, which is for a lease termination. So a lease non-renewal. So in a 5-day, right, that's because you didn't pay the rent. A 10-day is a component of the lease itself, right? That might be smoking. They might be, health and safety. A lot of leases have things like that, particularly when we're talking about issues of hoarding, obstructing the pathway to an exit, depending on what kind of housing you have. It could be owning a pet. That could be a lease violation, right? There are a lot of things that could be possible lease violations. And then a 30-day notice. So that's just essentially, there's no problem between you and the landlord. The landlord just doesn't really want to continue. They don't want to continue renting to you for a myriad of reasons. And so they have a right to not continue in that contractual relationship with you. And they're required to give a 30-day notice. So 30 days before the end of your tenancy. If it's a year lease, it's going to be 30 days before the end of your lease. If it's a month to month, right? You don't have a firm contract, you just pay rent and then they take it and you keep living there, then it's 30 days. So it's every month. It starts at the next month. And a key thing to know, right, is that it gives you the end of your tenancy. So let's say you get, it's almost the end of July, you get a 30-day notice, this week. You wouldn't have to leave necessarily, what is today, the 28th. You wouldn't have to leave the 28th of August. You would leave at the end of August, right? The end of the calendar date of August. So it's just something to keep in mind. Okay. So it has to be in writing. All eviction notices have to be in writing. Here, it's not enough that your landlord says you gotta leave, you didn't pay rent, go away. It's not enough that they text you, not enough that they email you. It has to be a written notice. And the notice has to be provided to you either in person, sent by certified mail, or posted on the door. So sometimes I'll get people that come to me and they'll say, you know, they told me that I have to leave, otherwise, you know, they're gonna evict me, and they got a text. Or they found a piece of paper lying on the floor. That's not enough, right? It has to be either delivered in person by certified mail or posted on your door. So maybe you have a mailbox, the landlord puts it in the mailbox. That's not sufficient. It has to be certified mail, right? So kind of like we said back before here, right? 5-day, 10-day, 30-day. When you think about that, there's two reasons for this, right? It's to let you know how much time you have left before the landlord can file an eviction. And it's also to let you know how much time you have to what's called curing the problem, right? That is to say you fix the problem. So to cure it, you have to do exactly what the notice says, and you have to do it within that notice period. So if we went back a couple slides, right, to 5-day, 10-day, 30-day. 30-day doesn't really apply here, right, because the 30-day is not wanting to continue the contract, right? So there's nothing you can do to fix that problem, really. But for a 5-day or 10-day, right, what we're talking about here is the idea that that you can, within those 5 days, if you pay rent, you can pay rent then, right? You can pay rent within those 5 days. If you're caught up, they can't file an eviction. It becomes moot, right? That means that is to say that like the issue no longer exists. They can't go to court and then try to evict you after they've already received the rent from you. And they can't reject your rent if you pay it within those 5 days. Same thing with a 10-day notice, right? So if it's for a lease violation, you fix the problem. Hey, you know, I know the problem was that I was smoking. I'm no longer smoking in the unit. You know, I walk 2 blocks away from, I don't know, the building, and that's where I smoke on the street corner. You know, that's what I've been doing, etc. I had a pet, you got rid of the pet. Now, things like smoking or other more habitual issues can sometimes be difficult, right, to cure and to prove curing it. And sometimes that's where you need an advocate, right, whether that's a caseworker or a lawyer. So you have to do it within that time period, otherwise it's no good. They don't have to take your rent, they don't have to take the change. This is an example of what a 5-day notice might look like. And so what I want you to sort of keep in mind is it lets you know that this is the rent that you owe, and that an only full payment is allowed. So if it doesn't say only full payment, there might be some wiggle room there, but most notices will say this. They'll say an only full payment. But what I really want you to think about is this, right? Whether we're talking about a 5-day or a 10-day, what we're talking about here is the landlord has a problem with what you are or are not doing. And they have to, if they're gonna evict you, they have to notify you of one, what the problem is and how to remedy it, right? So they can't give you a 5-day notice for a lease violation, right? They have to give you a 10-day notice for a lease violation. And they can't give you a generic notice that says, you know, you violated the lease, and if you don't fix it within, you know, 10 days, then we evict you. They have to tell you what it is that you violated, and so in order to give you a chance to fix it, right? So it's not enough that it's generic. It has to be on its face. That is to say, on the actual document, it has to say what it is, okay? So this is really important, documenting everything. You just don't know what might be important. I know what might be important to your case, and so getting as much documentation as possible. I will often see people who, especially who live on month-to-month, who don't have receipts, or who have an informal relationship with their landlord, and they text or they show up in person, they have conversations. You know, I talked to her on this day and I said these things. And it's better to have some sort of written confirmation, whether that's text because you have no access to email, or whether that's an email. I would love to see that. So let's say, for example, you have a problem with the landlord or the management company or the janitor. You want to follow up with an email saying, you know, earlier today, you know, on this, especially because the emails are timestamped, right? Their date and timestamp. So you can say, you know, we spoke about these issues, A, B, C, and the resolution was, you know, X, Y, Z. This allows me to have documentation as to what your conversation is. Whether or not it gets admitted into court later down the line, that's an issue or a problem for me to handle as a lawyer. But what is important, it gives me leverage when I'm talking to your landlord. It gives me leverage when I'm talking to your management company to say like, hey, I have here, verification, right? That, you said, yeah, sure, to this email, or you responded to this email, or I have documentation from the tenant saying, from my client saying that these things happen on this day. And it also helps with memory, right? Because our memory is faulty. It is for everyone, right? So, we say, oh, this has been happening for the last, couple months. Well, when did it start happening? Oh, I don't know, it was cold outside. Well, it's cold 6 months of the year. Like, what does that mean, right? And so oftentimes I have to do the work of trying to piece together a narrative that's the closest to recordable time, right? In order for me to be able to, with a sincere face, approach the lawyers for the landlord or a judge and tell them that this is what's happening and this is what we have in front of us. So, taking photos of conditions issues, right? If there's a problem with the conditions, take photos of it. If they're claiming that you did this or didn't do that, then, if there are witnesses there that were present, contact them. Let me know that there was someone that witnessed something, right? This can really help your case on the negotiation end, maybe even before it gets filed in court, which is even better, or if we are in court and I'm trying to negotiate with the landlord. And if it gets to trial, hey, I got witnesses, I get to put on the stand, right? So the last day of the notice, so it's after the last day of the notice that a landlord can file for an eviction. So if it's a 5-day, they can't file on day 3. If it's a 10-day, they can't file on day 1. They have to file on the 11th or the 6th. They have to file after, right? Now, they might be able to waive, you might be able to waive the filing, right? So let's say, for example, it's a 5-day notice. It's day 8, they haven't filed yet, but you paid the rent full and they took the money and you're still there. If they file afterwards, they waive their right, right? Even though you've paid after the fact. If they don't take your money, they have every right to, because the 5 days are over, right? It's only within that 5-day period that they have to take your rent. Otherwise, they don't have to. If they take your money, then they waive their right to court because the problem is solved, right? But they have to do it after, right? It's not, they can't just give you a notice and then 2 days later file. So this is what an eviction complaint looks like. It's pretty generic. They just put some simple language. There is something to note, and I don't think I put a slide here on this, but the Illinois Supreme Court just issued a new rule requiring landlords to include or attach the notice to the complaint. So it used to be the case that they just had to say like, didn't pay rent or, lease violation. And then you'd have to show up in front of the judge and the judge would be like, so what's happening? Now landlords have to include the cause for why they're trying to evict you, right? If it's for cause. So this is what a summons looks like. This is what a sample of it is. And it's just something for you guys to know what it's about. And it's just telling you that you have to go to court. So if I'm the landlord and I'm filing in court for you to, evict you, the judge has to then notify you, the tenant, that you have court, right? So they issue a summons and a sheriff's supposed to deliver it to you. A sheriff delivers it, so I'll talk about posting in a minute, but a sheriff normally delivers it in person. It has to be personal service, which means they have to give it to you, or they have to give it to someone in your residence that's 13 years or older. So let's say you live with family and your 16-year-old child is there, or your grandchild who is under the age of 18 is there, and they're staying with you. That is considered sufficient. That's considered proper notice, service, I should say. This is considered proper service. So it's not necessarily that they have to hand it to you, the individual, but they have to hand it to someone residing in the abode, that is to say the home or the house, the apartment, who's 13 years and over. And capacity doesn't matter as much. Like I had a client who had a child that was older but had a developmental disability. That still counted as service, right? The judge didn't care. Posting is just, it's another way if they can't get a hold of you of notifying you that that you have court. So that will often get mailed. So try not to. Sometimes these documents can seem scary and can be paralyzing. So if you see any court documents, please reach out to a caseworker, to a lawyer, someone. Okay. So there's an eviction filing against you, or you got a notice. That doesn't mean you're getting evicted, and it does mean you have a lot of time, right? So I want you to think about sort of the long-term game, and not really freak out in the moment, even though it is a very scary situation that you're in, understandably so. So here what we're talking about is what's called an illegal lockout. So an illegal lockout is what's often referred to as a self-help eviction. So it's when landlords can't evict you through a legal process for a myriad of reasons. Right now it's because of COVID and moratoriums. But in the past, it used to be just because it was expensive, right? You had to file, you had to pay for it, you had to pay for a lawyer maybe. You had to go through the hassle of going to court and trying to get you out. And so I might, as a landlord, try to make it difficult for you to continue living there. So changing the locks or windows, messing with the utilities or appliances, messing with your stuff, throwing it out. We're not even dealing with your living conditions. Let's say you have mold growing in your bathroom, or you have repairs that need to get done. The landlord is still under a legal obligation to fix those things. The landlord cannot touch your belongings. The landlord can't mess with your utilities. The landlord can't do anything that would make it so that you cannot live there as you normally would, because that would be considered an illegal lockout, right? Whether or not that was the landlord's intention, and like 99.99% of the time, that is their intention, right? Their intention is for you to leave, to feel so uncomfortable that you want to leave without them having to take you to court. So what happens if you have a legal lockout? Really, there's not much you can do except notify the landlord that there's a violation and call 311, right? So I, as a lawyer, have a lot more success in contacting a landlord and telling them you're doing something illegal, right? I can, my name's on it. It says attorney. I have a letterhead, and I cite law that says, what you're doing is illegal. Stop it. And probably about half the time it works, right? The landlord stops what they're doing, and they're like, well, we're gonna get a lawyer, and we're gonna sue, or we're gonna take you to court. And then they do, and then I end up having a conversation with a lawyer. And sometimes they're pleasant, sometimes they're not. But once I'm talking to lawyers, it's a lot easier, because then we can just go back and forth, and we can then talk to our respective clients. If that's not working, 311, especially in an emergency situation where you're completely locked out, like you can't get in, or especially in the summer and the winter, if the heat or electricity goes out and you need the air, you need the AC or the heat, calling 311 and saying, look, this is an illegal lockout. You have to send someone. My utilities have been cut off, or I've been locked out. I have a child, I have medicine, etc. And CPD is supposed to go and investigate. If they're found to have violated the Chicago Landlord Tenant Ordinance, which is the law that covers this, then they can be fined by the city anywhere from $200 to $500 per day of the violation, right? So especially when we're talking about utilities being cut off, if your utility's been cut off for 3 days in a row, that's $200 to $500 per day, even though it's one continuous shut off, right? And in court, you can get back your possession of the unit or your personal property. So maybe, you say, screw it, I found myself a new place, but all your things are in the unit because you got locked out. You can get your things, or you want to continue living there, so you can get your unit back. And you could also collect anywhere from 2 months rent or twice the actual damages sustained. So if you were hurt in any particular way financially, that is to say mostly your personal property or things like that, then you could recover twice whatever you actually were financially harmed by. And this is you can do a civil suit regardless of whether the landlord is fined. So you could sue them for an illegal lockout in court, even if they were fined by the city for this, right? So it's another avenue available to you as a tenant. So how do you know if an eviction was filed against you? You can look it up, right? A lot of times when people say, I got a notice, I got a 5-day notice, and a month later they're talking to me. Like, well, have you gotten a summons? And then they'll say, I don't know. So I just look them up, and this is, you can look at the slide and it'll show you exactly the steps you want to take. I would advise you to put your last name first and your first name second when you're searching it. And you put yourself as the defendant, not the plaintiff. If you know who the actual management company is, you could also put the landlord's name, but it has to be the company, not like the person you talk to, right? So it's not the manager, I don't know, Clarence Rose or something. It's Cass Realty. It's BJB Properties, right? It's whoever the actual company that owns it. Because they're the ones filing. So things that you want to think about if you're going to court, right? You're going to think about filing a fee waiver, which essentially is waiving any fees that you would pay and make it free for you to be in court, especially if you're low income. This is the Daily Center has a space in the basement, what's called the concourse level, where next to the Starbucks, where they have people that help you with this. But if you go to court and you say, hey, I don't know what I'm doing, someone can usually direct you. And the judge will oftentimes, if you don't have a lawyer, they'll say, do you have a lawyer? And you'll say no. A lot of times the judges will refer you to this free resource in order for you to find a lawyer. Worst case scenario, always ask for one. It gives you some extra time to find a lawyer. In truth, most judges want you to have a lawyer because it's easier to deal with you with a lawyer, right? A lawyer knows what's happening in court and how the process works. You don't, and it makes it that much longer. So they have a bunch of cases and they want to go through them really quickly. You file an appearance, filing an appearance. So here what we're talking about in this checklist, we're talking about if you're what's called pro se, right? You're arguing in court without a lawyer. And you file an appearance, you basically say, hey judge, I'm here, right? It's a piece of paper that officially tells the court you are present in court. And then the last is you indicate you want a jury. So we often suggest people want a jury. You have a right under the Constitution to receive a jury trial, and that includes an eviction court. So the good thing about a jury is that at least pre-COVID, and we'll talk a little bit about the changes, but when you get your first court date to go to eviction court, there's no jury box. It's just a courtroom. There's a gallery where people sit, and then there's the tables for the defense and the plaintiff, and then the judge's bench with the clerks and stuff. But there's no jury box. So if you ask for a jury, what you often do is called the jury transfer. So it transfers you to another courtroom for another date. It buys you time, and then it puts you through the jury trial process, which is a bit longer. So this is a way for you to buy some time while you're figuring out the situation, whether that means moving out, whether it's negotiating with the landlord. I, as a lawyer, will often use this because it's just a right? Unless I from the beginning think that this is not a good jury case, or I think I can fix this or settle this without doing a jury, then I won't. But otherwise, I almost always get a jury. I almost always ask for a jury because it's the right, and you can deny it later. Like you can waive the jury later, but it's much harder. It's much harder to get it back if you waive it from the beginning, right? So it's better to waive it from jump. So the fair notice ordinance. So back when we were talking about, and here I will actually, as we're talking about this, the fair notice ordinance is a new law that passed on Friday by City Hall. And it's an amendment to the Chicago Landlord Tenant Ordinance on the issue of notices. So if you'll indulge me going back a couple slides to the notice slides, here, what we're talking about is this 30-day notice, right? So for a lease termination, you're supposed to get a 30-day notice. The law has changed starting any tenancy, that is to say, any lease whether a month-to-month or a year lease that ends 90 days from Friday. After that, if you've lived in your residence for less than 6 months, you only get a 30-day. If you've lived in your residence for 6 months to 3 years, you get a 60-day. If you've lived in your residence for longer than 3 years, then you get a 120-day notice. Okay? And the requirement that it has to be in writing still applies. So if you were supposed to get a 30-day notice, then and you didn't get it, then you get 60 days on top of your tenancy. So let's say, you know, was it July 31st is when the month of July ends. If July 31st is the end of your tenancy and you didn't get it in writing, you didn't get your 30-day in writing, and you've lived in your apartment for less than 6 months, then you get 60 days on top of July 31st to move legally. If you lived there from 6 months to 3 years in the apartment and you didn't get a 60-day notice, then you get 90 days on top of it. So July 31st, 90 days on top of that. So 90 days after. And then if you've lived in it for more than 3 years, then if you don't get 120 days, then you get 120 days on top of it. So 120 days after the end of July 31st is when you would get it, right? This applies 6 months after Friday. So if your lease ends tomorrow, I'm sorry, but if your lease ends 90 days from Friday, or 91 days from Friday of last Friday, then you're golden in terms of this. The other thing I want us to, the other important thing that it talks about is the 5-day notices, right? So we look over here to the 5 days, talks about unpaid rent. So remember before when I said, oh, you have to cure the problem within those 5 days. Well, the new amendment says, the new ordinance says, hey, you get a one-time with one landlord, a one-time per landlord, I should say, a one-time per landlord curing period of up until the order of possession. So let's say I'm your landlord, you're my tenant, and you come to me and I give you a 5-day notice, you don't pay rent, great, I file. You go through court, weeks, months later, we're at trial, and you have all the back rent. That then waives the eviction. It dismisses the eviction, right? You've cured the problem, but you only get it once. So it dismisses the case and it drops the case entirely. So it only happens once per landlord. So if you do it again with the same landlord, too bad. Even if you have all the money plus extra, you know, day of, you know, the judge says, you're about to get an order against you, too bad. You already used it once. If it's a different landlord though, you're golden, right? So it's a one-time per landlord. You can cure your non-payment of rent up until the issuance of an order of possession. This is big because sometimes you just don't have the money, right? And if you can get the money by the time of the before the judge issues the order, then it can, you know, they can drop the case and you can get it sealed. Okay, so I'm gonna jump ahead. Please don't get whiplash as I go through this rather quickly. So we're talking about sealing and eviction, right? So what does this mean, right? It basically is when I tell the court, I know that there's a filing against this person. Please seal it so that no one can see that there was an eviction against them. And because when you have a filing, not even an order of possession against you, not even an eviction technically against you, you just have a filing for an eviction, the credit agencies will record that. So you apply for an apartment later, or maybe you're in the middle of litigation, right? And you're arguing with the landlord. If you're, and you're applying for an apartment in the middle of that because you want to get out, it'll pop up on your record, and then landlords will say, you know, oh, they have an eviction. They may not even look at the situation. They may not know that you have that maybe you're in the right. Maybe it's a bogus situation, right? They don't know any of that. They just see that it's on your credit report, that's on your record, and then they don't want anything to do with you, right? So I sometimes will get ahead of this by writing a letter for clients explaining the situation and that we're arguing in court, so that when they apply, we confront it, right? We can tell landlords, hey, future landlords, hey, we know this is going to pop up in their record. This is a situation. And then we'll talk about eviction on, so how does this work? You know, you motion it up, right? So if we're in court, it's easy to do. We just put it on the order, you know, whether that's, you know, the order against you for the order of possession, or whether that's an agreed order to dismiss the case entirely, we'll ask for a sealing. But if the case is old and there's a filing, then we have to then motion it up again. We have to submit something and then bring up the case. And you risk, right, because at that point it notifies the landlord of the situation. You risk the landlord coming back to try to collect unpaid rent, right? Maybe that might not be an issue for you because you're judgment proof, right? That is to say, you don't have any income that they can garnish or take. If you get it sealed, it's always better to get a copy of that order and then contact your credit reporting agencies and let them know that it's been sealed and that you want it removed from your credit report, because sometimes they will still show up, okay? So here what we're talking about is the just housing ordinance. And basically it's that landlords are only allowed to take into consideration convictions against you within the last 3 years. Anything prior to that, juvenile records do not count, okay? So they can't, in the rejection of you, they cannot base it off of prior criminal record older than 3 years or a juvenile record, with exceptions. And the exception is generally what we're talking about here. We're talking about sex crimes. We're talking about being on the sex offender registry. We're talking about, you know, child stuff, right? And a lot of those kinds of crimes are not covered. If you have a conviction within the last 3 years, the process you're supposed to do is you're supposed to decide whether or not you're a good candidate to rent to first. Then they have to do the background check. And once they do the background check, they have to notify you in writing that the reason for it is because of your record, and give you the opportunity to explain why, right? Explain either why this happened, why it's bogus, why it's not a big deal, or, and more likely, proof of rehabilitation. So this is where having a caseworker or lawyer is really helpful, because they can present evidence of rehabilitation, right? You know, this person has been going to group therapy, this person has been going to AA, this person has, you know, got their GED, this person XYZ, and there's all these different factors that they're supposed to take into consideration for rehabilitation, right? To show that, you know, even though they have a conviction against them within the last 3 years, they have shown that there's been rehabilitation. They're not likely to reoffend again, and thus put, you know, the health and safety of their other tenants building themselves at risk. And I believe that is all. So, okay, so orders of protection, DV stuff. So what I want to talk about here is one, you know, we're going to talk a little bit about moratoriums and why that doesn't that affects domestic violence a little differently, because you have a right to, you know, go to a safe space, even if there's a stay-at-home order, or even if there's a moratorium on evictions. But the thing I want you to keep in mind is the Safe Homes Act makes it so that you're being a victim of domestic violence or a survivor of domestic violence, use it as a defense in an eviction case. So if there's an eviction case against you, you can use DV as a defense. This is often really important, particularly because, you know, if you're living with your abuser, with the aggressor, you might be in a situation where, you know, you're not paying rent, or you're not the person in control of the finances and that kind of stuff, and all of a sudden there's a filing with your name on it, right? And that could damage your credit, that could damage your record, and make it difficult for you to find alternative housing, right? Which is really important for you as a survivor of domestic violence. And also the Safe Homes Act makes it so that, this act is statewide, the Safe Homes Act makes it so that you can also get a change of locks. The landlord can do it for you, or you can get someone else. The landlord can charge you a reasonable fee for it, right? This is not so great for people who are lower income, particularly if landlords don't want to take the burden of paying for the change of the locks. But they are legally allowed to charge you a reasonable fee. What that is, it doesn't say in the act, but my assumption is going to be market rate, right? What's the market rate for changing of locks to your local locksmith? This is where it might be good to also contact caseworkers and stuff like that, particularly in the DV realm. Oftentimes, as someone who used to work a little bit in that world, some advocates and caseworkers know of people who have the contact of specific locksmiths that will do it free of charge for domestic violence survivors. Now, the issue here is also, how do you prove this, right? So you're a domestic violence survivor, you're trying to use this as a defense, or you're trying to change your locks, right? You're trying to get your landlord to comply in a particular way. And the best way, honestly, is an order of protection. But that requires you to go to a courthouse. That requires you to, testify in front of a judge against the aggressor, saying, this person was emotionally, physically, and or sexually abusive towards me. And that is, it's difficult for many people, right? So going through that process can be difficult and can be re-traumatizing. And some people don't want to go through that. Some people are in abusive situations, but they just don't want to do it for a ton of different reasons, very legitimate. And so, unfortunately, that is the situation. You kind of need an order of protection for most things in order to use domestic violence as a protection. Getting a police report can help in some situations, but an order of protection is necessary. So evictions, right, under COVID, right? How does this work? So we talked about the court process. We talked about, what's going to happen when you go to court, and how, 5-day, 10-day, 30-day notices. This has all really changed because of COVID and a lot of the new laws that have been issued because of it. So one thing to keep in mind is that the governor has been extending their moratorium several times, and now it's until the 22nd. So that basically means no new filings, no enforcement of eviction orders, except in very limited circumstances. And here what we're talking about is some special, criteria that the governor's executive order has said regarding health and safety, or in violation of building code, certain criminal activities, but really essentially all around. There's just no new filings. There are no enforcements of eviction orders currently. That said, court has opened again, and it's open since July 6th. But these are all cases before the moratorium in April. So if a case was filed before April, before the moratorium was applied in mid to late April, then I think April 25th, then it does not apply here, right? This is only cases that were filed beforehand. And actually, before I talk about CARES, I do want to talk a little bit about how court is working right now. So the way court works right now is you can either show up in person. There's two ways to show up in person, and then there's showing up virtually through Zoom. If you do end up having court and you have to show up, you can do Zoom. And reach out, if you have a caseworker, reach out to your caseworker and have them contact me. I can probably get them the Zoom link, like the Zoom account and password to their courtroom, and they can do it virtually. And maybe they can, finagle some sort of situation in a computer lab. You can also show up in person, and there are kiosks where you can do it virtually. The line is very long though. So, think about the fact that you're supposed to do 6 feet distance. So getting into the building is long, getting on the kiosk is long. You can show up in person to courtrooms for many of the courtrooms, but they're limiting it to individual party, to the parties themselves, I should say. So if you're not a party, before you could just sit there and wait to get called. If you're not a party to the case, they're not letting you into the courtroom. That also means that you're probably just, as far as I can tell, loitering in the hallway with a bunch of other people. So that's also a health risk for you and for other people. So it's just something to keep in mind. And they're trying to stagger them so that, before it used to be 9 a.m. all the morning calls, and they just go through them, as quickly as possible. Now they're supposed to do like 9, 9:30, 10, whatever, et cetera. So it's just something to keep in mind. The other thing is the CARES Act. So in March, the federal government issued the CARES Act, passed the CARES Act, and it provides a bunch of different protections, but essentially until July 25th, it's just passed. No one who lived in subsidized housing could get noticed for non-payment of rent, and they could not file, right? And if you gave a notice, it had to be a 30-day notice. So no 5-day, no 10-day, no 30-day, no 5 or 10-day, it's 30 days. That said, most subsidized tenants do receive a little bit longer time, at least many of the ones I've seen. It's not usually a 5-day or a 10-day, it's a little bit longer. The rules will change depending on where you live. But because you sign a different contract when you're a subsidized tenant, that said, you're supposed to receive a 30-day notice for anything where the landlord wants to notice you up for an eviction or in any way. So that has just passed. It is suspected that the Congress will pass another similar CARES Act Part 2. We don't know yet until they do, right? So there's that. And what it also, so tenants that are covered are so they also can't have any late fees, and they can't give notices, like I was saying, until the 25th, and it has to be a 30-day notice. So, a lot of times for non-payment of rent, you would, get a late fee if you paid rent late. No late fees here, right? So from March until now, if you weren't paying rent, they couldn't give you a late fee, and they had to give you, they can only give you a 30-day notice starting from the 25th. So how do you know you're covered? One way to know you're covered is to look it up. So here's some links there. The slides will get shared, and you can search to see if your property is covered. So if you're a subsidized tenant, like you have Section 8 or public housing, you know that you're subsidized or covered under CARES. It's pretty generic. If you're covered under some sort, if you are a private tenant, belong to a building that is covered, that is federal, that's backed by a federal program, your building might be covered under CARES Act. So I might be, that is to say, I might be a private tenant. I pay market rate, but CARES might apply to me. So maybe they're not allowed to charge me late fees. Maybe they're supposed to give me a 30-day notice, and maybe they're not even supposed to notice me until after the 25th, right? So it's of July. So you may want to look at, and this is something we do with our clients, we look to see whether their building is covered under the CARES Act. And one way to do that is through these searches. These are 3 examples. There's like multiple of them. And I will be honest with you, they're kind of hit or miss, the results are inconsistent. That said, the Illinois Supreme Court has issued a rule that is supposed to apply retroactively that says that any landlord that files an eviction after March 25th has to issue a statement, a certification, has to certify that they are covered or not by CARES, right? So this helps with the runaround with this. So this is sort of just talking about what I was saying, who would qualify under CARES. And it's also important that you report any changes in income. So if you're behind on rent, if you were affected by COVID because of whatever, let's say you had to work less hours, or you became unemployed, you're receiving unemployment, et cetera, that is you should get an interim recertification. And there are forms. If you have issues, please talk to your caseworker, and they can contact me, and we can refer you to a place where there are, you know, standard forms where you can use to give to your property manager or to your subsidized agency, CHA in this case, most likely, or HUD, that says, you know, I would like to request a recertification, an interim recertification because I've been affected by COVID, and that you want to apply it retroactively to when the change happened. So it's especially if you just found out about it, then but you became unemployed in March or April, you want it to apply retroactively, okay? And so, sort of I was saying before, right? So here are the sworn statements saying that their tenant is covered by CARES. This is really, really important to keep in mind. So what happens when the eviction? Oh, so this slide should have been changed, right? So August 22nd, right, is the new date here. And what happens? Well, then, you know, landlord can start evicting you or trying to evict you, especially if they've given you a notice. This can get tricky because we're sort of in a in limbo here, right? We don't really know how this is all going to pan out. There's suspected there's going to be a bunch of mass eviction filings, and landlords, we have seen an uptick in landlords engaging in self-help evictions, that's to say illegal lockouts, because they want people out sooner rather than later. So it's good to get legal advice if you can. If anyone has tried to file against you within these dates, please contact legal aid immediately. That is illegal and should not be happening. If it is happening, if they're filing against you, then it's literally a clerical error. The clerk's office should not be allowing this to happen. So, you know, please contact legal assistance. And here, I also want to bring us attention to this new Chicago COVID eviction protection ordinance. So here, this started in June 15th, but it's retroactive. And it says that that after a 5-day notice, you can give the landlord a notice of COVID impact statement. So this notice of impact statement gives you an extra 7 days before the filing of an eviction to make a good faith effort with each other to negotiate. So if you got 5 days, add 7 to that, and you're looking at extra time that you can negotiate with your landlord regarding your non-payment of rent. And they're supposed to engage in good faith. You know, what good faith is, it's not super well defined. We'll see how the courts define good faith once evictions start happening and landlords are bringing this up. And tenants use this good faith argument against the landlords in court. Here's where you can get a written notice of impact statement. It's just sort of like a form you can use to give to your landlord. And you want to, like you said before, document everything. So you want to keep track of all these things. You want to keep track of all these conversations. You want to take photos of things. You want to make sure you have this all in writing. So they don't need to reissue you a new notice if you file a notice of impact and after the fact. So let's say you got a 5-day notice in May, they can't file against you, right? So at least not until after August 22nd. So, but you give them a notice of impact statement now, right? Well, the 7 days start now. And so you have those 7 days for them to engage in good faith. But they don't have to reissue you another one, right? They can stay with the old 5-day notice. Here, we're talking about emergency rental assistance. Here's some possible assistance out there. The city just came out with new rental assistance. I believe they announced it yesterday. It's like going to be enough for like 10,000 people or 10 million people, something like that. 10,000 people. There are not 10 million people in Chicago. 10,000 people. There are 3 million people in Chicago. But anyway, so so there is going to be like millions of dollars for rental assistance for thousands of people. So it's a lottery system, though. You want to go online, contact your caseworker, and they can find it online. It's on the city website. And you fill out a form with your information, and it's a lottery system. So just keep that in mind. Carpools is a hotline for free legal aid. They give you legal advice, but most likely referrals. So they'll give you advice and referrals to other legal aids. They're a good clearinghouse for legal assistance. And Legal Aid Chicago is the largest civil legal aid in Cook County, so they're usually the go-to. They mostly only do subsidized housing though, so it's just something to keep in mind. Rentervention is the program through the Lawyers Committee for Better Housing, and Lawyers Committee for Better Housing does do private. So if you live in private unsubsidized tenancies, they will represent you. Rentervention is sort of their like online situation where you can go and you can text or you can go online and they have a prompt. They also have a Spanish version. It's I think rentervention.com/es. And you, instead of texting hi, you text hola. But it's same thing. And that's my office. Sans me, because I wasn't working there at the time the picture was taken, but it's a lovely slide to end on. So I'm open to questions. If there's anything that you all have questions about, maybe I forgot to mention something, or I went through something very, very quickly, which I think I've done.
I was really quick, so I did get a couple questions come through the chat that I'm going to just read to you, Gerald, in a minute, but I did want to make sure I mentioned to everyone, because I think I neglected to mention at the beginning, we are recording this presentation, and we will make the slides available to everyone after this. So if you missed something, that will be made available. So, especially I know there were a lot of links in the PowerPoint to click on directly, so don't worry about that. One question that came in was the regarding the one time per landlord option, where you can have till the actual notice to vacate comes through to cure. Is there a particular step the tenant needs to take? Do they need to notify anyone they do that, or does that go through automatically?
So that's a great question. This just passed. I do not believe you need to notify anyone. So, if you, because it's a one time per landlord, right? So let's say, I'm the landlord, you're the tenant, Sean, and, we're in court and you, or even before court, and you come up with all the money, but the 5 days have passed. You say, okay, fine, I have to take this money. So you take it. And then, 6 months later, we have the same problem again. And I come to you with the money before you file or after you file, but before you get an order, before I get an order of possession against you. I'm going to say, no, I don't have to. I don't want to. And the judge might ask, especially if you have a lawyer, the lawyer will say, hey, Your Honor, the tenant has already done this before and they're trying to do it again. Our client doesn't have to take the rent money per this ordinance, right? So people will know. And if they don't and they take the money, then they waived it, right? Because there's already that issue, right? Like you could, in theory, come to an agreement before. You could have always come to an agreement to dismiss the case before the issuance of an order of possession. What this does is force the landlord's hand to take your money, right? So before, you could have just agreed to it. Like, let's say I'm the landlord and you're the tenant, Sean. You could have, Sean, come to me with the money at the 11th hour, and I could have said, you know what, honestly, all I wanted is to get paid, so whatever, let's do this. And then we dismiss the case entirely, right? You pay everything minus attorney's fees. That's the other caveat to that. You have to pay everything, like the filing fees, all that stuff, minus attorney's fees, and then, good to go, right? But I didn't have to do that. Now, I have to, as the landlord, but only once. So if it happens again, if it happens a third or second or third time, I'll say, I keep coming to agreements with you, Sean, but you keep doing this. I'm not doing this anymore, right? I don't have to. I'm fed up, right? So if it happens with another landlord, then that's another landlord. You get another one to go. So.
Another question that came through was regarding when the landlord files for eviction. You mentioned something about they have to now include notice or reason. Is that like they have to actually include a physical copy of the 5-day or their own just statement about what's happening?
Yes, they have to now include the actual notice. So in the original complaint, they just had to say what was happening. So there was like, so-and-so didn't pay rent, or so-and-so violated the lease because, they keep bringing a dog and, I'm allergic to dogs and it's a lease violation or something like that. but now they actually have to attach the notice. So this is big because sometimes landlords don't give proper notice. And so then it's part of the record, right? We don't have to wait until discovery later on, weeks later, when I get a copy from the landlord attorney saying, you know, where I look at this and I go, on its face it's bad, right? Let's get this dismissed. The judge can see it from the beginning.
And then the last question that got posed to me in the chat that I wanted to bring up was regarding trials by jury in the time of COVID. Is that still a thing, or juries all remote, or how does that work?
So that's a great question. Yeah, so I have a real answer and a not so real answer. I mean, the real answer is yes, right? It's a constitutional requirement. You have a right to a jury. Are jury trials happening? I'm not sure. And I think some would say that a specific strategy that you could employ is to request a jury and see when you get one. And who knows, right? People are having a hard time, the court's having a hard time getting jurors, and what's called impaneling a jury, right? So, you know, getting the jurors, asking them questions, voir dire, all that jazz that you see in TV shows. That's really hard. It requires a lot of in-person stuff. It requires groups of people. It requires a lot of scheduling. That's really hard to do right now, but you have a right to it. So you can ask for it and then see when you get it. And it may be a while, so.
That was it for questions that came through that I directly wanted to bring to your attention.